We just want to pop you back to the Bridget Mabandla Justice College. That's where the Madlanga Commission is on a short adjournment. Senzo Mchunu, the minister who's been placed on special leave, back in the witness box. Canny Maphanga is our senior reporter inside the room, and she joins us now live once again. And Canny, we've been listening to the minister since just after 8:30 today, and the commission is going through his evidence with a fine-tooth comb to try get a sense of what really substantiated that decision to disband the PKTT in December last year.
That's correct, Ayanda. Good morning to you and to the viewers. Remember, we did discuss earlier this week that the defense that he seemingly constructed before this probe is not necessarily in harmony with the conduct and the manner in which he decided to disband the PKTT. And that is why the questions continue to mount from the vantage point now directly at that directive at itself, and of course the kind of instruments that he used as a justification, or what he's trying to suggest may be a justification for the decision to disband the PKTT. Remember, we've heard evidence that this was a decision that was done as a form of a surprise, as none of the key top management or key role players within the PKTT itself knew that this decision was coming, and it was immediate, meaning they understood that it had to take place immediately. Now, we know he's walked it back about the meaning of immediate, but there is still stuff in that directive that warrants a number of questions that he will have to clarify as the police minister, as he tries to continue with advancing this point, or attempting to advance a point, that the decision was rational and above board. You may remember that in the directive he says that the task team is now constitutionally and administratively untenable. Now, if we focus on the former and not the latter, he says that he used a work study report, that of Murray. But the cross-examination has been able to discover that Murray's reports actually had nothing to do with the question of dissolving the PKTT, and in addition to that could not override the IMC, who in the minutes have never expressed any concern about the PKTT, and instead have said continuously in those minutes that the PKTT must continue with its work, it's doing good work. So he couldn't advance that particular justification, and it was put to him by Commissioner Khumalo that he is merely putting this work study report before the Commission in a means to justify that indeed that decision was above board. Again, more flaws are being identified in this argument of it being constitutionally untenable, because if you're saying that task teams can no longer exist outside the structure of the South African Police Services, why is it the only team being disbanded is the PKTT and not the other 10 that exist? If this disbandment was not really a disbandment, but rather an integration into the already existing SAPS organizational structure, then why did it only lead to the disbandment of one particular team and not all of the teams that were operating at the time? Now, if he also says that he was consulting, or he had received grievances about the PKTT and alleged human rights abuses, how did he use that as the final conclusion without at least testing the evidence with various key role players, but the first point being that of the National Commissioner? We're now hearing before the Commission that he actually didn't speak to him at all about these human rights abuses that were being alleged about the PKTT, and he is stating before the Commission that that is one of the reasons why he used one of those instruments to justify his decision over the 29th, 30th and 31st. Again, Ayanda, this common theme in the cross-examination of Mchune coming up yet again, that the circumstances and the manner in which he took that 31st of December decision is not in harmony with the foundation he seeks to try and lay before the Commission to make the decision above board. In fact, what it does is that it raises more questions about why he disbanded the PKTT and what the possible motive or alleged undue influence, if that is the case, could have been in driving him to take such a rushed, hurried decision that really overrid all of the key role players within the establishment of the PKTT, didn't consider those IMC minutes or the work of the PKTT, and of course came as a surprise to all of the parties involved. We expect that the questions will continue to mount for the police minister, who is now on a leave of absence, that is Senzo Mchunu, after the tea adjournment adjournment, and you'll continue to get a number of questions surrounding the strange nature, as it has been described, in which he took this decision and how he didn't consider or act in a manner that would have been expected of the minister to take such a decision that has such a significant impact, not only on the PKTT itself, but in the areas that it was serving at the time that the decision was taken. Over to you.
Yeah, and before we let you go, Canny, of course, as all of that was happening inside the Bridget Mabandla Justice College, breaking news coming from the courts that Dumisani Khumalo is now able to essentially get back to work. This is a connected story, of course, because part of the claim made by Nhlanhla Mkhwanazi is that there had been efforts to try frustrate the work of the PKTT, and these bail conditions were listed amongst those efforts.
Indeed. I haven't had a chance to read the full judgment. However, what we are seeing from the Gauteng High Court in Pretoria is that they found that this decision was arbitrary and didn't exercise the necessary judicial discretion when it was taken by the particular acting chief magistrate. And of course, we've heard from Lieutenant General Mkhwanazi, this was part of a critical component of his evidence when he was dealing with allegations about the judiciary. He felt that in those particular bail conditions, rather, that it was a suspicious bail condition to set, that to say while they're on this criminal trial, they may not enter any crime intelligence office across the country. This meant that they won't be able to do their work, and we know that Khumalo is integral to the work of the PKTT and also the fight against organized crime, because not only was he the project lead for the PKTT, but he's also the head of crime intelligence. So they saw that as a form of alleged interference, or rather the judiciary allegedly acting in protection of these criminal syndicates. And this is one of the members of the judiciary that they made that allegation against. We know that there is also an allegation against the top judge of the Gauteng High Court division, and of course those are still being tested before the commission, and there isn't yet an indication as to whether those particular individuals have been served with Rule 3 notices and when they are scheduled to appear before the probe. But we know it won't be in this first half, and we know that both have indicated that they would need to give their version before the Madlanga Commission. So it is expected that that particular allegation will have to still be tested and combed out before the commission, probably in the next year when phase 2 is expected to intensify in this highly important probe.